Thank you. Okay, so the background of this is that Jim Wilroy wanted me to give a presentation on trust administration, and I thought that was a good idea since we do a fair amount of it. We also do a lot of tax, we do some probate, do some trust administration, and a variety of other services. And trusts and estates and tax, that's our area. Myself, Rex Crandell, and my assistant Tamara, who is a very competent office assistant. Disclaimers. Of course, we have to have disclaimers. We're not creating an attorney-client or CPA relation, and I'm not about to give you advice on what's practice of law because I don't know how to do the distinction. Okay, what I'm going to go over today is, first of all, we're going to cover a first death in a couple and then a second death in a family, and what documents are needed. And it's kind of like a kaleidoscope because a lot of the different things that you have to do for trust administration seem to be somewhat disjointed, but hopefully I can tie it all together for you. You start the trust administration generally when one of the spouses of the settlor, creator of the trust, dies, or the other thing that happens is when a trustor, settlor, becomes incompetent. Then that's another time when a trust becomes irrevocable. And once it's irrevocable, then someone has to take over. The successor trustee, who was named, takes over the responsibility for the assets. So this is set up for law office or LDI office. Initial contact, remind the client to bring in documents that are needed, make the initial meeting as soon as possible. And what that means is within 2 or 3 weeks after the person's passing and after funeral and memorial services have been concluded. One of the first things that we look for, the shortest time frame, is lodging the will with the superior court in the county where the person lived. There's no penalty that I know of for not doing it, but we try to comply with the law. And the way this is done is you have to bring the original will. They won't take a copy. And then we bring a copy and pay the $45, $50 to lodge it or file it. And then we ask the clerk to take the original will, lodge it, and then stamp our copy with just the rubber stamp that they are using. And we're not talking about a fancy $35 certified copy or anything like that. We just want proof that that process has been taken care of. So overall, 3 steps: notification, meaning beneficiaries, interested parties, stakeholders; marshaling of assets, which means control and management; inventory, finding out what assets are controlled by this trust; and appraisal, figuring out what the assets are worth. And then after a lot of procedural steps, we'll look at allocation and distribution.
I'm sorry, this is Tamara. Back on his 3-step process, one of the only other things that I could think of that is really important is for you to get a copy of the will and the trust and make sure the person you're communicating with is the actual successor trustee or who is the next in line. Recently we've had a client call in and she wasn't the she kept telling us she was the successor trustee, but then, and we went through all these steps, but then by the time I got a copy of the trust, I found out she wasn't. She was the second in line. So I had to tell her, okay, now all of a sudden
we can't
talk with you because you're really not the successor trustee. You're a beneficiary, and it creates a conflict of interest.
So make sure you get the right person. And checklists in the handout material today, I've provided you a very lengthy 8-page checklist for trust administration. It's extensive and not everything applies. There are simpler ones, but first you need to find out what kind of assets or what you're dealing with, because all different types of irrevocable trusts come with different requirements. Basically, we use the checklist to determine which way we're going. We don't usually give the client a copy of our detailed checklist. And as we go through and find out what the circumstances are, we might add additional steps that we feel are necessary. When a trust becomes irrevocable, either because of a death of the settlor or because of incapacity, the IRS wants to have you get a federal ID number, taxpayer identification number. What we do normally is when the client is here and we're starting the trust administration, is that Tamara will we'll get the information. Tamara will be on her computer, her desk, and we get the taxpayer identification number for the fiduciary, the irrevocable trust, while the client's waiting in the office. So we get the copy of the official IRS letter, we get the new ID number, and we name our office as the third party designee so the IRS can give us the number. And then we give copies to the client and advise them that the accounts that were in the name of the decedent, the Social Security number is no longer usable, and you have to get the new ID number in control for all the bank or financial accounts. If it happens to be a husband and wife and only one of them's passed, then it's not as critical because you can just take one of the names off and the survivor's Social Security number will stay on that particular account. Either before or at the initial interview, scan the trust to see what is going on in the trust. Look at the provisions for formulas, powers, what is the intent of the settlor or creator, and then we prepare an internal form. We call it a pink sheet because we print it on pink paper. And after the meeting, I read the trust in detail and summarize the provisions so that we don't have to go into the full-blown text every time we want to review a certain point on the trust administration. So the next one talks about a disclaimer. They're not that common these days, but what is common, unfortunately, is there's a lot of old trusts that were created back when the inheritance tax rate was much lower, and it says you got to split the trust. And with the inheritance tax rate starting for an individual at 11,580,000, we don't have that many bypass trusts anymore that are needed. They may be required, but we'll talk about ways to get around that. But one thing with the law changing in 2025, with the inheritance tax rate going back down to, I think, 3 to 5 million, is that now we can build in a disclaimer in case the trust is not amended in the future, and should inheritance tax be applicable in a couple, husband and wife, and one passes, the spouse can disclaim part of the trust, not being a required AB trust, but then save on inheritance tax. Okay.
One thing though that to keep in mind when it initially happens is it's extremely important though if you have a husband and wife and there is kids from a prior marriage or kids prior to the marriage, then it's extremely important to split the trust because of the fact that the distributions later on are not going to be the same, and the kids from the prior marriage will feel that they've been shortchanged somehow, some way. So one of the things that I really look for as soon as I see a trust is if there's any explanation, and or I'll ask the client, are there any kids from a prior marriage, and or does the surviving spouse have kids that were not part of the marriage? So that's one real big thing that I ask right away because it makes a huge difference.
And my assumption when a client comes in, they're the successor trustee, is the majority of people have not ever been a trustee before. They don't know what they're getting into. And usually by the end of the whole process, they're muttering under their breath saying, I had no idea it was going to be this much work. And had I known I had to do this much work, I would have never volunteered for this job. But it is what it is. And somebody has to take care of the assets of the decedent. And I tell them, you know, you're basically helping out your loved one. And yes, it's a lot of work, but they would have done it for you. And in terms of the trustee's duties, instead of me going through a big training program, I try to use the Judicial Council Form DE 147, which I'll show you in a moment, because it very succinctly describes what a trustee has to do. No commingling, have to deal with the best interest and the decisions for all the beneficiaries, no favoritism, absolutely no commingling, no split interest. If you have family members working for the trust, they have to get fair market value wage, no more, no less, and disclose. Another thing I look for is a fidelity bond required. For most trusts, it's not, but I've experienced too many trusts where the trustee was thought to be responsible and they ended up not being, and they raided the cookie jar and took out a whole lot of money. So oftentimes if there's a bond provision, I think that's a good thing. But here is the form that Judicial Council 147 that describes the duties for the trustee. And when we're doing a probate, they have to sign this and turn it in. But it's got the requirements. It's not in great detail, but it's enough to inform the successor trustee what their duties are and what their conduct should be. And it doesn't take me much time to explain it because they can read that on their own. So now we get into the notices. When a trust becomes irrevocable at any time because of incapacity or death, the probate code requires notification to all the heirs, potential heirs. Now, that's a broader category than just the named beneficiaries. Even a beneficiary who was not included in a trust, they still have to get notice. And there's good reason for it, which will help the trustee. So what is the notice? I have an example in the next slide, but basically you're telling the heir or beneficiary that this loved one has passed on and the trust has become irrevocable. Person sending it is the successor trustee who's in charge of the assets. And then the trustee needs to decide if they're going to send the entire trust or not to the beneficiary or heir, or just tell them that they have a right to obtain a copy. Well, in our office, we want to control the sending of this notice because we've had problems where some beneficiaries have selective memory and they claim they never got it. So we treat it like a proof of service that it's sent from our office, and we have a proof of service that it was actually sent. If it's a real cantankerous potential beneficiary, we might send it certified. And and the other factor is we always send the trust with the 16061 1.7 notice because we want to shorten the time. What we're talking about here is the heir has 60 days from the date of the notice to contest the trust if they want to, and when the trust was attached. If the trust was not attached, then they have 120 days to contest the trust, or they lose their right.
Okay, hold on. Sorry, I'm going to read the question from Robin. Who exactly would be the potential heirs whom you must also notice? I myself will go ahead and answer. It has to be anybody and everybody in the family, or a church they attend. We've had quite a few people, or trusts in the past where the successor trustee goes, oh my God, I don't want to give Aunt Susie a copy of this trust from John because it may say personal thing, or she may feel bad because she was left out. That is not the successor trustee's call to make on who should and should not receive a copy. When we have clients, or I tell them that you must, anybody and everybody, because anybody could have the right to contest it, and you don't want the trust, you don't want to get in the middle of it or get towards the end and all of a sudden Aunt Susie pops up and says, hey, I never got a copy. He told me that I was going to receive the Cadillac, and I want to know where my Cadillac is, and then you're fumbling around like crazy trying to figure out what happened.
So it protects the subsequent trustee from claims, and we insist upon it. And essentially, you're probably aware of the table of consanguinity that shows intestate, and that's basically all the people that get noticed. If they're on that chart for consanguinity on an intestate situation, dying without a will, then you want to give them notice of the irrevocability of the trust. And on the screen here, I've included a sample of a model form for your information on what's included.
Okay, we have one more question. If one spouse dies, can the successor, other spouse, change the trust, remove a beneficiary the decedent wanted, or does it become fully irrevocable?
Okay, there's more than one answer to this. What happens when a trust, a husband and wife, when one passes, the trust, I look at it like a ball, it splits in two halves. We have the decedent's separate property and half of the decedent's community property in one container, and the survivor, all of their separate property and half of the survivor's separate property in another container. Now, if it's an AB trust, there's no question. It cannot be changed as to the decedent, and that's very important. Now, if they have a trust that I call the I love you trust, that allows the surviving spouse to amend, adjust after the first death, the trust itself allows it. So there would not be ability to stop the trustee from changing the document. And if I was drafting a document and there were children from prior marriages, no way. You have to protect the reliant interest of the spouses. And in this case, the spouse who's passed would be in more jeopardy of losing the assets for their offspring. And sometimes what we'll do is draft so that the successor trustee includes one of the beneficiaries from the deceased spouse's prior marriage. And that pretty well puts a police supervision over the administration. But answering changing the trust, I have a slide for it later on amending the trust. I'm going to defer till we get to that. Okay.
Okay, go ahead. No more.
Inventory of assets. So where we are in the beginning of a trust administration is, are we going to be doing a trust administration or a probate? Of course, you would assume that we're doing a trust administration. I don't assume anything. What we do is when we get the inventory of assets, we examine the title. Who owns the asset? Is it in the name of the trust or in the name of the decedent? And so we have an asset list, which I have included in the sample forms for you, a model, and it breaks it out by community, separate property. And so we look to see the market value of the assets that are not controlled by the trust. And when that asset list gets over 166,250, we're likely going to have to be doing a probate, perhaps in addition to trust administration. Now, when I say assets that are not listed in the name of the trust, keep in mind that pension plans, life insurance, annuities are never really owned by the trust. Those are separate trusts that have a designated beneficiary with the vendor that they've contractually agreed who is going to be the beneficiary. So that is not a probate asset. It transfers by the beneficiary statement that we should verify. Now, hopefully we don't have a probate to do, and that's the purpose why the majority of people do create a revocable living trust. And in addition to inventorying the assets, we'll get into it a little later on, we're going to value the assets also.
One thing, Rex, tell them what happens when you have, like, say, for instance, a vehicle, it was not in the trust, and how do you know what to do with it?
Good point. Yeah, a vehicle, motor vehicle, and also mobile homes frequently are not in the name of the trust. They both, Department of Motor Vehicle and the Housing Department in California that controls mobile homes or motorhome ownership, you basically bring a certified copy of the death certificate, and they have a form that's an affidavit of death, and you say that I am transferring the property to myself, I am the person in control. There's a copy of the will or the trust, or a statement that there is none. And DMV seems to be fairly lenient on allowing that happen. It's kind of scary if somebody's got an expensive car that, you know, I don't know what would stop somebody from getting a death certificate and going and putting the Lamborghini in their name. But it is what it is, and unfortunately it's not a court process.
No, basically I was thinking more of the process. Say, for instance, they have a trust, they have a will, they did not put the vehicle or a thing in the trust name. Tell them the document you must use.
Oh, okay. It's not just the vehicle. So I focused on when she said the vehicle. Now I'm going to broaden the category of assets. Now, in the middle of that screen, it says a 13100 form. Well, what this is, it is a form that we've included example for you that we're not going to do a probate. We don't have over 166,250. And the successor or the administrator, who's ever in charge, fills out this form and says under penalty of perjury that I'm in control of this. You need to transfer control to me. We just had one with a bank, a credit union, where the credit union would not give the successor trustee the asset. We filled out one of these forms, and as part of it, the vendor is informed that if we have to take them to court to exercise the rights under this law 13100, that the vendor has to pay all the legal fees. And for some reason, the credit union finally found out the way that they could give it to the proper person. And before I leave this page, I'm going to just touch on the word Hegstead. Sometimes people will refinance a house. They had it in the trust. They did it all right. They go in and they refi. Now, title companies and banks maybe don't put it back in the name of the trust after the refi. So when the person passes away, the house is outside the trust. I understand some title companies are prohibited from bringing it back into the trust. So we have this case that says because it was notarized, identified, and specifically listed on the Schedule A in the trust with the proper assessor parcel number and the legal description, that the court treats that equivalent to a deed, and the court will allow the transfer of the house into the trust without a probate, which is a time and money saving event for the trust. The screen I have on now is an example of a 13100 declaration that describes what I was just saying. So it's the step-by-step. The only thing I left off was the notary portion, and it gives any third party, it could be a safe deposit box, it could be bonds, it could be stocks where there's more involved if the person owns stocks outright. There's a procedure with the registrar that's a little convoluted to get the shares reissued, but this is the form to get assets that are outside the trust when we're not doing a probate.
Okay, I have the question.
Okay.
So this is from Lori. Is providing this form to vendor UPL? I'm not sure what UPL means.
Unlicensed practice of law.
Oh.
It's something LDAs never do, so it's not a problem. But go ahead. What's the question?
Is providing this form to vendor UPL?
Okay, so let me go back to that form and let's take a look at it. Well, I think what LDAs need to do is fill out forms that have been either on government websites or issued by an attorney or some other source where the LDA is not choosing the forms or giving legal advice. And quite frankly, this form, I'm an attorney, well, and a CPA, but I'm an attorney and I've given you this form. It seems to me it meets that criteria that an LDA could fill it out because this is the purpose, and it's not really like the LDA is choosing the form. An attorney is saying this is what you should do. So that's how I would address that situation.
Okay, and one more question from Colleen says, oh, we file all these forms?
Okay.
Not all the time.
Okay, so the question has to do with the word file. Now, with what I do, the word file is used a whole lot of different ways. This particular document, the 13100, is a form that you have notarized by the successor trustee, and you physically give it to the vendor, the bank, the third party that's holding assets, and it's not, quote, filed anywhere. It's not filed. When I think of the word filed, I think of the word county recorder and making it a public record. That's not what's happening here. This is between the successor trustee and the vendor who's holding assets that they need to let go of it by operation of law, or they're going to face some liability if we have to bring an action to enforce it. There are a lot of documents that do need to be recorded in the county recorder's office, some just filed with the assessor, and I'll try to point out those distinctions as we go through. But this is not a recorded document with the county recorder's office. So we're inventorying assets, okay? Oftentimes the assets in a trust are sold, divided out for the beneficiaries, and they're given cash based on their percentage or what the trust says. This particular document is for a situation where, let's say there was 3 rental properties, 3 beneficiaries, and the trust said, we're going to give 1 house to each beneficiary. Well, you probably heard the term stepped up basis under Internal Revenue Code section 1014, where a property goes up, increases in basis for capital gains purposes for the recipient as of the date of death, That's why we need an appraisal to prove it. And a trustee has the responsibility of telling the beneficiary what their basis is for gain or loss. Doesn't apply if the trust sells it and distributes cash, although the trust in its tax return will show the stepped up basis, and usually there's no gain or loss to the trust fiduciary tax return.
So this form comes much later, much later.
Much later, but it is part of the inventory, and I wanted to get you thinking that these assets are just not assets. You don't really care that Ma and Pa Kettle bought the house in Rich Oaks for $20,000 50 years ago, and it's worth 4.2 million now. This is important. We need to get a qualified appraisal for 4.2 million to avoid any gain.
I have another question. Please repeat the code section 1014.
Okay. Yeah, in Internal Revenue Code section 1014 is where it describes the value or the reason to increase a basis, tax basis for gain or loss on a decedent's passing. The logic behind this code section is when I started, the inheritance tax rate was $625,000. So we had a lot of inheritance tax returns that we were doing. So what happened was this code section said, well, because it was subject to potentially having inheritance tax, it's not fair, if they have inheritance tax or not, we want to make it as a fair market value at the date of death. And that's why we need the appraisal. But it was because of the inheritance tax, and they never got rid of that code section when they increased the level of the inheritance tax above $11,580,000 per spouse.
One more thing I'll add to this, just using my own experience, that was very helpful for. So I inherited from my grandfather some annuities, and I did a little bit of a different thing. Instead of having my auntie, who was the successor trustee, sell them and then give me cash, I did a kind of tiny bit of a sneaky thing, and
Not sneaky at all. It's strictly appropriate.
But I did a transfer in kind, which
Yes,
means just
fully
transfer exactly what he had, his
Don't sell
stocks, his amount, over and just put it in my name. That a couple of reasons: I didn't have to pay the stockbroker fee for selling it and then giving me cash. And it was just very easy because I don't know much about the stock market, so I have no clue what I would have even put it in. So what my auntie did with me on this was we did the transfer in kind, and at the date of death, we completed this so that if I should at any time sell any, and I did, and I'm going to tax court with the IRS because there was an error. But anyway, I get a stepped up basis at the date of his death. What happens a lot of times is the stockbrokers will, when they issue a 1099, they issued it for what he purchased the stock for. So there is a purchase price, and then there is a sales price you must include on your tax return. Well, it was a huge difference that when I took out a tiny bit of money for my kids' college, then I got to, the IRS taxed me on what he purchased the stock for. So now I went back and I'm filing a claim or a case in tax court. And I'm going to, and I showed them that I did have a stepped up basis, copy of it came from my grandpa, copy of his death certificate and all this. So I currently myself have a case in tax court, which I don't have a date yet, but where I'll go fight that I don't have to pay taxes because of that stepped up basis. And because I have this form from the beneficiary, that is my evidence in tax court.
Yeah, we advise the clients on securities we just ask the brokerage house to give us the value at the date of death. It's the high and low value on that particular day. The brokerage houses are used to getting this request because it's needed all the time. And on the screen I have in front of you, the middle paragraph describes what we're talking about. It's called an in-kind distribution. It doesn't mean you're being nice to people, although you might be, but what it means in trust administration is you're giving assets, not cash.
One more question before you go. So can a 1035 roll also? That's from Colleen.
I don't know what a 1035 is.
I don't know.
I know what a 1031 is. That's a tax-free exchange. 1035. I'm sorry, Colleen. I don't know if that means it's a pension. When we're talking about pensions, pensions do not get a step up in basis, and this is huge. So if you inherit an IRA and the value of the stock went way up inside the IRA, when you take the money out, it's going to be taxable. So that does not follow the in-kind rule, but I can't tell you what a 1035.
She says a 1035 rolls annuities or tax deferral assets.
Okay, so what we're talking about there is rollovers, and what happens with the pensions or IRAs, pensions, annuities, is if you roll them over within the same vendor or you don't touch the funds, it's not usually a taxable event. Like you're all familiar with an IRA rollover or a 401k rollover with trustee to trustee where the beneficiary never touches the money. That's not a taxable event. But having said that, the IRAs and pensions do not get this stepped up in basis.
Okay, we got 10 minutes, so let's roll through.
Okay, so trust certifications. Now the trust certifications, we frequently don't get them. If people have done them in estate planning, our clients, when they come in, usually do not have them. And their purpose, it's also called a synopsis of trust. People have an aversion to putting their personal information and recording it at the county recorder where it's public for anybody to see. So if you find a need to record the trust, and some people advise recording the trust, or in this case, an abbreviation where you leave out all the details, fine. And that is supposed to help real property. We frequently don't use the certification of trust because what we do is fill out a form and record it. It's an affidavit of death of co-trustee, and it accomplishes the same purpose. So it lets the world know who's in charge of this property now. But a lot of people will use them. Some things it's required, fine. If they want to record that, you can record, and it does give public notice that the trust exists, and also supports the fact that the successor trustee is in charge.
No, go the other two lines. I didn't see you saying.
Okay.
So sorry to interrupt, Rex. We actually have till 1:15 to go ahead, so we're good for several more minutes.
Okay,
perfect. Thank
great.
you.
Thanks, Rob.
Okay.
Gave me a new lease on life. Okay.
Since surviving spouse.
Okay. So financial institutions, they all have different rules, as Jim Wilroy has pointed out, that when you go down and try to change the name of an account to the new name of the trust or the successor trustee, some will allow you to copy the first few pages and the notary page of the trust. They'll go with it. Others want the entire trust. Sometimes a certificate of trust is good enough, but we always advise contacting the financial institution first to see what they will accept. Oftentimes, they have their own form, And in that process, before the accounts are changed over, make sure you have the new federal ID number if one is necessary.
So one quick question before you leave. Lucia says, so is that the only benefit of recording the certificate of trust, to make it a public record and to say who the trustee is?
That seems to be the way that I understand it. You can read more of it on the code section, probate code 18100.5. Nowhere have I seen that it is required or that there's a penalty for not using one. And quite frankly, we frequently don't see a need for it, and we don't want to do any extra work for the client that's not going to benefit them. But it's a trust in California is not registered. Some states do require you to register your trust or record it, but not in California. But I think that's the only benefit. It gives public notice of the successor trustee and the existence of the trust. This is an example of the certificate of trust, a model form that could be used to fill out for this purpose we've been describing. Now, the estate tax return. In estate administration, the area right now of estate or inheritance tax, the proper name is the estate tax because it's on the estate, not the beneficiary, but it's a complete waste of time in the majority of cases, because if each spouse has less than $11 million worth of assets, we're not talking about estate tax returns. So going through the whole process, and when you bring in gift tax returns, that's another gyration. And at the end of the day, there's been a lot of discussion about nothing, because only about 1% of the estates in the United States at the present time are required to file an inheritance or estate tax return. One reason we will file them is what's called portability. If one spouse does not use up the full $11,580,000 once in a lifetime exemption, then we want to carry that to the surviving spouse so they can have more of an exemption in the future. But I'm not going to spend a whole lot of time teaching everybody how to do the estate tax return, because 99 times out of 100, you're not going to have to be concerned with it anyway. But one thing I did want to point out is a problem with terminology. An estate tax return is for the value of assets above $11,580,000. That does not mean that when an estate or trust has income, let's say on dividends or interest or sale of property, that does not mean that they're not going to pay income tax on that money. This is not what we're talking about here. This is just based on fair market value.
It's a different return number, right?
Yes, when a trust or estate has income in excess of $600 for the year, then a fiduciary tax return on an IRS form 1041 and California FTB form 541 needs to be filed. It's required. If a trust or estate has less than 600 of income, even though you have an ID number, even though they may have had $300 to $400 of income, a fiduciary or estate income tax return is not required. And sometimes a trustee will just fill out the form with the name and the ID number and say 0 income, so they don't get a letter from IRS later stating, where's the return, and having to respond that I didn't need to file a return. Accounting. The majority of trusts that I see do not require an accounting. If a trust is silent to the requirement for accounting, the probate code says that any beneficiary can request an accounting, and if refused, they can be forced by court to give the beneficiary an accounting. And this type of accounting is fiduciary accounting. It's not what they teach in CPA school. I know it's completely different. It revolves 100% around the California probate code, and it's different. A lot of CPAs don't know how to prepare these accountings for a trust. And if a trustee hires an accountant that doesn't know how to do it and they pay the accountant, the trustee, the beneficiaries object, and then the trustee has to pay money out of their own pocket because they messed up to have the proper accounting done. So it has to be in the proper format. And this is just one sample. It's the summary sheet on a court accounting. It's on a judicial council form GC 400 sum, and shows the original assets, what came in, not necessarily whether it was taxable or not, what went out, not whether it was deductible or not, even beneficiary distributions are going out, and then what the assets are at the end of the accounting period. And there's 34 different schedules that can be attached. This is a required form for probate, conservators, and guardianships, and it's an optional form for trusts, although the format has to be the same.
And just to go back on that, I will say it's, well, for probate, it has to be done. Can you go back to the form again,
Sure.
please? It has to be done on a yearly basis. For LDAs, I will tell you, if you do not know how to do this, jump on the bandwagon, because every law firm that we're in the Bay Area or the North Bay here farms these out. They do not do them, so they do farm them out. Typically here, you can get about 95 to, I'd say 125 an hour to do this. Most successor trustees and or special administrators with a will do not know how to do this. It could be very cumbersome to learn and do, but once you get it down, for me, it's a piece of cake. But of course I know it and I teach it. So so if you haven't learned how to do this court accounting, it would be a great asset to be able to say that you do know how to do it.
Yeah, and I agree with that 100%, that the LDAs could expand the service mix of their services offered to the court accounting, and you're filling out court forms. That's what LDAs do. It has to be in this format. Every guardianship has to have one. Every conservatorship has to have one at the end of the first year, and then every odd year after that. Every probate has to have one. And Tamara and I teach a class on probate accounting or fiduciary accounting, and the judges just love it because they get these individuals who are pro per, and some people have anathema to the numbers, anything in numbers, and their eyes gloss over. And then the court requires them to do a court accounting, and my gosh, the judges are just having a tough time getting a lot of the pro pers to do the court accounting in the proper format.
Okay, hold on. So one question, I'm gonna go back to Colleen, sorry. If it costs them $600 to file the form for $600 profit, do you still have to file? That's one. And then the second question from Vita is, are these slides going to be available later?
Okay, the first question has to do with taxability of income on a fiduciary tax return, a federal IRS form 1041, California FTB 541. What the criteria is, if there is more than $600 of income, not net, just gross income from adding dividends, adding interest, adding stock sales, adding anything, the positive number of income, then you have to file the fiduciary tax return. And whether you actually pay the fiduciary income tax or not is not the question. You have to fill out the form. And unless there's tax due, there's nothing to pay on it. But the problem with the fiduciary returns is the fiduciary returns tax bracket is the highest bracket. So you don't want to leave the money in a trust or an estate if you can distribute it out to the beneficiaries, because if the trust or estate pays the income tax, they're going to pay way more than the individuals if it's distributed out in a K1. The maximum tax bracket in a fiduciary return is at $11,500 of taxable income. That's equivalent to $335,000 of taxable income for an individual. So we're talking very condensed and high taxes in the trust and estate tax returns. This is a flyer. If anybody wants to attend our class, it's coming up in June. We give it at the Martinez Superior Court Law Library. And this is, we just have one more in this series, and then we're going to have another set, and there's no charge. All the information's there.
So real quick, just on that one, you are taught the petition that's turned in with that, and then that court accounting. So we go through that GC 400, all the schedules, and the petition that's filed when you ask, which he'll explain on this slide, the petition where you ask for distribution and payment to the trustee.
Right, and in that, the class on the court accounting, the trustee, if it's a probate case, or if a trust can be brought before the probate court and it is treated under the probate rules. Otherwise, you just leave it outside. But for all probates, all guardianship and conservatorships, the attorneys, the guardians, conservators, and the executors cannot get paid until they do the accounting and put the petition in the accounting explaining to the judge why it was appropriate for the attorney to get paid and the trustee or administrator to get paid. Okay, on the death of the second spouse, we have a series of questions to go through, finding out what is needed for the administration of this estate. If we did not have an ID number already, say if we had an I Love You trust where it never became irrevocable until the second death, then we would have a new ID number requirement. We still, at that point, need to marshal and inventory the assets, notify the trustees, basically the items that we discussed above. Okay, this is we had talked about it briefly before, the notice to the beneficiaries of the irrevocable trust, inventory of assets and appraisals. One of the things with appraisals that I find interesting, we need to have them, especially for real estate. We want a professional appraiser, and but a lot of people are not aware that there's a probate referee, and the probate referees have to value all assets for all probates. And optionally, if you have a trust that you're administering, you ask them, they're appointed by the court, actually by the state controller. There's about 5 probate referees per county, and they will appraise any asset. And one of the reasons I like using the probate referees, they're private business people, they're not government workers. The reason I like them is because when they do an appraisal, it comes out on a court form, looks very official. And it's maybe not as much quality as a licensed professional appraiser, but it's functional and it's economically.
And if you have a contentious beneficiary, or possibly somebody who might state, oh, I know mom's wedding ring was worth $5 million, and you state it's only worth $100,000. You can always, you have the appraiser as your secondary person that says no, it wasn't worth $5 million, and it can't happen. We've seen it quite a bit.
The probate referees will value most anything unless it's a specialty item, like jewelry, coin collections, stamp collections. You might have to get a specialist appraiser, or if they got an antique auto collection. But the probate referees they're very useful to use for valuing assets. Now, in the area of real property, when a trustee has passed away and the successor takes over the responsibilities as a successor, we file what's called an affidavit of death of trustee with the county recorder's office that tells the world that we have to file it with a certified copy of the death certificate, this affidavit under penalty of perjury, and it's notarized. It tells the world that the previous owners passed on, that the successor trustee is now in charge, and that clears the title for the trustee to be able to do their job. Now, that is a recorded document. There is a separate document that goes directly to the county assessor's office, which is also a notice of death of real property owner, but that is specifically for the assessor to be on notice. Maybe there's a possibility of reassessing and getting more property tax. And we found that the county assessors are very enthusiastic about increasing property tax. For some reason, a great deal of enthusiasm there. The other form that needs to be filed whenever you're working with deeds in the county, as Rob will tell you, is the preliminary change of ownership report. And that you have to file with the deed, and without it, they'll charge you a $20, $25 fine, but they really don't want to record anything without it. And there again, the purpose is to alert the assessor of the possibility of increasing property tax.
You have about 5 minutes.
Okay, thank you. So another thing that's extremely important in trust administration is real property. Now, when a house has had a really low basis, when the parents, let's say, died and now the beneficiaries come along, the first thought is just sell the house and divide up the income. There's not going to be any capital gain because of step up in basis. But I always point out to the successor trustees, don't be so fast on this decision, because if the property, the house, the apartment building, whatever, gets transferred into the name of the children, then you can claim a parent-child exclusion up to $1 million of assessed value, not market value. And the net effect is, like, we have a transaction that's going on right now in Orinda where the house was originally bought for about $50,000. Now it's worth about $2.5 million. And if the two children end up getting the house, then we claim this exclusion, and their property tax would end up being about $15,000 a year less. So it's important. That's on Proposition 58. So it's important to consider that.
Rules and everything. And he said
I hear some other talking in the background. Perhaps somebody else has a microphone on. Okay, 2 minutes. Affidavit of death of trustee we spoke about. Here's the change of ownership, death of real property owner for the county. Application not to reassess parent to child. And there's a grandparent-grandchild exclusion from reassessment if the parents are passed away. There's a co-tenancy exemption for people who own property together over a year. And registered domestic partners can also take advantage of that. Normally, when I'm making distributions out of a trust, I'll use a grant deed because of the warranties of title. And this is an example of the details needed in a grant deed. I try to stay away from the quitclaim deeds because there's no assurance that you own anything. I can give you a quitclaim deed on my ownership interest in the Golden Gate Bridge. Is perfectly legal. I don't happen to own anything, but you can still do a quit claim on that. Here's the example of what we talked about, preliminary change of ownership report, affectionately known as a PCOR in the industry. It tells the assessor certain facts to see whether they'd be able to reassess or not. Okay, one little sense of if a trust has an LLC in it and there's a change of over 50% ownership, this is a big deal for reassessment. Now, we're getting along in the process. We're going to be distributing pretty soon. So we distribute a distribution agreement among all beneficiaries. We do that to root out objections potentially. And we can request a waiver of accounting. We can get their approval. And we can request a release of liability for the trustee, but you cannot condition a distribution, say, we'll give you your distribution if you sign off that you're not going to sue the trustee. Can't do it. So don't even try. And additionally, the distribution agreement provides for all the trust assets being distributed and the trust disappears. So we talked about it before with blended families. Make sure that those trusts are split according to the document. This is the section somebody asked about revoking a correction, amending an irrevocable trust. Here's the code sections that allow it. Either all the beneficiaries get on board with it, or you get the court involved. I'm not going to read the details. One thing that is huge in this area of trust administration is property tax. If you mess up property tax, you could have a situation where a client is going to have to pay $10,000 to $12,000, $15,000 a year forever because the documents were not done right. So this is huge. And I just pointed out that, you know, if you end up putting it, it was supposed to go to one spouse and you gave it to both, and it was not a full parent-child exclusion, or if the property gets split 4 ways with 4 kids and then they start dividing it up, that ends up being reassessed. I don't have time to cover all the details in it, but it's huge. So looks like we're out of time. I do want to thank you for allowing me to join you today and present these issues. I also want to make it available to all the CALDA members that if you have any questions about trust administration or tax or anything else, we're here. We'll be happy to answer your questions. You can either call or send us an email, and we'll be happy to try to help you if it's something that we can do for you. So I think we've used up all our time, which is not surprising. And I hope to give more presentations to you in the future. Thank you. Bye now.